despite the fact that we had originally hoped to not be having a committee meeting today, but we are here to do a work session on LD 1945. We'll welcome the bill sponsor onto the panel in just a minute, but let's start with committee introductions. And I'm just going to call on folks as I see you on the screen. Representative Moriarty, go ahead.
Thank you, Madam Chair. Good morning to everyone. I'm Steve Moriarty. I represent Cumberland and part of the town of Gray in House District 45.
Representative Reckitt.
Morning, I'm Lois Reckitt and I represent District 31, which is the ocean end of South Portland.
Representative Newell.
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell and I represent the Passamaquoddy tribe.
Representative Evangelos.
Morning, everyone. Jeffrey Evangelos, House District 91. I live in Friendship, and Madam Chair, I have an appointment at 10 and I have to leave around 10 of, so I hope we can get Representative O'Neill going fast so we can vote.
Okay, thank you very much. Representative Sheehan.
Thank you, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Representative Thorne.
Good morning, Madam Chair and committee members and those in the viewing public. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and Etna up in beautiful Penobscot County.
Representative Babbage.
Good morning, all. My name is Christopher Babbage. I represent most of the town of Kennebunk, all of the hinterland, but only a small portion of the shoreline. That is House District 8.
And Co-Chair Harnett.
Thank you, Madam Chair. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside.
Thank you. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, where I reside, and a little bit of Scarborough. And I'm happy to be here this morning with all of you. And this will be, I think, our last committee work session, other than the errors bill, which will come at the end of the session. Let's see. So I'm going to open up and I would like to introduce our analyst, Janet Stocco, who has joined us this morning, and also our committee clerk, Susan Panett. Thank you both. And now we will begin the work session on LD 1945. The sponsor is going to join the panel. And I'd just like to outline how I think we can make good use of our time together this morning. There are about 5 issues that I think that we should discuss and consider whether we want to make some small adjustments in the proposals. I'd like to do those first, and then we can have committee discussion of the 2 proposals that were circulated to committee members, interested parties, and were posted on the committee website yesterday. And so is that everybody good with proceeding in that fashion?
Yes.
All right, great, thank you. Okay, and so I'm just going to dive in. First dive is to welcome this bill sponsor, Representative O'Neill. It's nice to see you. And so I'm going to go over these 5 points, and they really relate to what has been called the proposed combined amendment. And just go over them and let's discuss each one. So the first has to do with the effective date. The current draft contains an effective date, I believe, of July 1, 2023. That's on page 7 of the draft. There is some concern that the nonpartisan OPLA staff raised to me about implementation date versus when the general effective date for legislation passed in the first session of the next legislature would be. And there might be a conflict here. because if the legislature, sometimes the legislature adjourns in June, sometimes it doesn't adjourn until much later. And so I would like to, I'm going to make a proposal. My proposal would be January 1, 2024. I think the bill sponsor would encourage us to have an earlier effective date. So I'd like us to hear from the bill sponsor, and then let's talk a little bit about that issue. Representative O'Neill, go ahead.
Thank you, Madam Chair. So the thought process for this piece and the idea behind all of these amendments was to hopefully combine the idea of the study and passing the bill in the hope of bringing more people along. The delayed effective date is part of that thought process. It gives folks more than a year for compliance and education. If folks would want to tweak it so that it isn't July 1st, 2023, I would encourage it to be fall of 2023 rather than January 1st of 2024. I think it's already plenty of time and that we need to get these protections in place. A compromise that I just thought of as the chair was speaking was for the analyst. I'm wondering if it's possible to draft it so that it says the effective date is the same effective date as legislation passing in the first session of the 131st legislature. I'm just thinking on my toes here, but I think that might be a way, or if folks wanted to provide a clear date, I would like to hear from the analyst on when a good date would be to set. Like, I would like to hear when things typically take effect, and if it's usually September or October, we could say November to be safe, for example.
So I think that could be a clever solution if the idea is to allow the study legislation that might come out of it to be effective. I have a couple of thoughts just off the top of my head. I think we could draft it that way. And if the revisor's office doesn't like it, they will certainly tell us. But what they really like is clarity. And I think that could be a clear date because it's 90 days after the session. My only caution, which just immediately pops into my mind, is we did have a situation in the first regular session of this legislature where not much of the work was done in the first regular session. And there was a quick adjournment and most of the work was done in a special session. And that would be my only caution. If that might happen, you would need some kind of amending legislation in the meantime. And then if it's July, August, September, October, I think is generally the effective date.
Madam Chair, do I have permission to respond?
Yes, go ahead.
Thank you. I would tend to agree because I would want there to be a clear date in statute. So would you be able to talk about the typical dates when we didn't have a time frame the way we did last session, what that would look like, whether it be September, October, November?
I believe it's usually mid-October because if you adjourn around July, 90 days later is October, I think. But if I'm calculating wrong, just correct me.
Okay, I think I'm just too sleepy to think of it. So I provisionally said November, thinking that gave a little bit of give. But it's in the committee's hands, of course.
Representative Babbage?
Yes, thank you. Janet, at this point, I hope first names are okay, even though we're official here. When you specify a clear date, the clear date would be met by the provision of 90 days after the close of the legislature. Isn't that true? I'm thinking that the common day of implementation of new law is kind of a good way to go here. And so I don't think by clear date we need to say October 1st or January 1st or whatever, do we? I mean, 90 days after the adjournment of the legislature would be a clear date? That's my question. Thank you.
Thank you, Representative Moriarty.
Thank you, Madam Chair. I have a question for Ms. Stokoe, and that is whether there are any constitutional problems in targeting the effective date as coinciding with the effective date of a succeeding legislature.
None springs to mind. I will certainly investigate that if that's what you vote to do, and we will definitely tell you if there is one. I would say, just to clarify from what Representative Babbage said, when I was talking about the revisor's office wanting a clear date, they need to know when the law is in effect. So for them, I think that would be a clear date and they wouldn't have a problem. That is a completely internal to our offices, separate question from whether you think politically, for a different reason, a clear date that people can predict in advance for people who are bound by the law. I just want to be clear that I wasn't trying to weigh in on that. I'm just saying for the revisor's office purpose, they like it to be clear to everybody what date they need to say this law is in effect, when they put it on the website or whatever. And I think they could say 90 days after the session. I think that's clear, but I would have to defer to the revisor himself in case he disagrees. I think he will agree, but I can't promise it.
Yeah, I think it's clear as well. The question is whether there's a constitutional issue, because the Constitution normally, or in fact does specify an effective date for the acts of one particular legislature. And if we tie the effective date to the adjournment of a future legislature, I don't know the answer, but it occurs to me there may be a constitutional issue there.
Thank you. Representative Harnett?
Thank you, Madam Chair. I understand that a clear date can be in words or a date, precise date like November 1st or whatever it is that's chosen. My only concern about the 90-day language is the concern that our analyst raised, and that is how things transpired last year with the budget, where there were really two different effective dates of legislation. So I would tend to want to pick a date rather than a description of a date, whatever that date might be. You threw out January 1st, 2024. The sponsor has spoken about November 1st, 2023. That gives me more comfort than a language description. Thank you.
I have a question for the bill sponsor. From my perspective, I feel like January 1, 2024 gives ample time both for any additional changes that need to be made in the first session of the 131st to happen, and it gives everyone who has to comply with this law some more notice than the November 2023 date. And I'm just curious as to why you're advocating for November 2023 as opposed to January 1, 2024.
Absolutely. Where I'm coming from is I think Mainers need these protections now. I think we needed them yesterday. So that's my thought process. It's very accommodating to give a year and a half. So I think, but whether it's November or January, I think it's most important that we pass it. So
okay,
whichever works for the committee.
All right, thank you. Committee members, would somebody like to make a suggestion so that we can kind of resolve this issue and move on to our next one? Representative Moriarty?
Thank you, Madam Chair. I don't mean to sort of scramble the works by moving into your additional points, but they're all sort of intertwined.
Okay.
And, what I envision that ought to be done doesn't really involve beginning with the selection of an effective date, but rather what really should transpire in the meantime. So
Okay.
I'm open. I'm really. I'm not saying we shouldn't select one. I'm just saying it's possibly premature as to how we approach the broader issue and the study committee.
Okay, yeah, I'm just trying to take things off of our to-do list. But we can definitely postpone this until later on in our discussion. Representative Rackett?
Well, I do agree. It makes sense to pick the date at the end, but I want to make sure we pick a date. And when we do pick a date, my preference, frankly, is January 1st, in part because November and December are months when almost nothing in the world happens in this state other than family and Christmas and Thanksgiving and all that stuff. So I think it's much easier to remember January 1, wham. For me, it's going to be, well, now, was that November or was it December? You know, I just think it's January 1st seems very clear to me. And it's the day after my birthday, so I remember it easier. So, but I'm not married to it, so whatever.
Okay. All right. Representative Sheehan?
I think I'm just going to echo Representative Moriarty and Representative Brackett's thoughts on this. I would like to, I'm open to either, but I think I'd like to have a little bit more discussion about the study process itself, and I'm open. So.
Okay, thank you. Okay, so the next language issue that has been raised is the use of the term aggrieved. And Janet, can you remind me where this is in the?
Certainly, it's on page 7 of the proposed combined amendment. It's 9607 subsection 1.
Thank you. And can you please, do you mind screen sharing that section? This is the private right of action. Thank you. And thank you for making it big on the screen. Okay, so committee members, the original proposal that, or a preceding proposal used the phrase an individual aggrieved by, and we've received a suggestion that should be changed to an individual alleging a violation may bring an action against an offending party or a processor. And let's first hear from the bill sponsor on the reasons underlying the suggested change.
Thank you, Madam Chair. So I sent this over to Peggy on March 15th when we had originally come up with the idea of combining all this, and it was really a language review issue. So I'm just going to read what I sent to Peggy. I said, Peggy, for language review, I noticed that section 9607 should say an individual alleging a violation rather than an individual aggrieved by a violation. This will better reflect the intent of the bill as I presented it, referenced in my testimony and other communication. Otherwise, the language could create an unnecessary legal question. This was something that came up in Illinois, and they had to decide whether it was alleging or aggrieved, and where they settled the question was alleging. And then I'll go back to my email. It was otherwise the language could create an unnecessary legal question. And I gave some context for data protection law. Some courts have prevented victims of data breachers from receiving identity protections or having credit monitoring if they can't show that someone has stole their identity yet following a breach. That's harmful because the victim's information is already out there and they can't do anything about it. It's really just a matter of time before data brokers get their hands on it and start exchanging it forever. But the victim may not be able to show how it's harming them yet. So that's just one example of how this issue shows up in privacy law. And And then I quoted the explanation from my testimony saying that the law in Illinois works this way too. So it just adds a point of clarity and prevents confusion. It was one of the pieces I wanted to include as we tailored the law.
And so just to clarify, so the wording used in the Illinois law is alleging rather than aggrieved by?
No, so this, I think it says aggrieved by, and what happened is it created a question. So what I don't want to see is a question of if someone breaks the law and sells your biometric data, like they sell your fingerprint. I don't want the court to be saying, well, did that really hurt you? Has it hurt you yet? And the plaintiff will have to prove that. I want it to be clear that if a company sells your biometric data and it gets out there, the harm is already done because the data is out there and you can't get it back. So that's the thought process, and to make it consistent with the law in Illinois.
So I'm just, so using alleging would make it consistent with the law in Illinois, or does Illinois still use aggrieved by?
So as you know, there's what's in statute and then what the courts have done with it. And it makes it consistent with what the courts have done with it so that Maine courts don't have to deal with that question. We've made it clear. We've resolved an ambiguity.
Thank you. Representative Rackett?
I'm a little concerned or not understanding why there needs to be a private right of action on this, and what that really means in terms of a person who feels like something's happened. I mean, why would you, if this is a state law and somebody's enforcing it, I have no clue who, why does it have to be a private right of action? Why can't the law just be, enforced?
Thanks for the question. So the Office of the Attorney General is listed as an enforcer as well. As we know, that office has limited resources, and something that we've seen for how this law has played out in other states, which are Washington, Texas, and Illinois. Only in Illinois have meaningful suits been initiated, and has there been accountability because of the private right of action. So that has been the teeth that has made the law be enforced and ensured compliance. Because as you know, our Attorney General's office is great and does great work, but it takes a lot of resources to fight a company like a social media giant. And that's why the private right of action is essential, to let regular people enforce violations of their privacy in court.
Could I follow up, Ann?
Yes, please do.
It seems to me that on major companies or entities violating stuff in Maine, unless my brain has died, which is entirely possible, we have given the Attorney General, at least in some cases, the right to use contract attorneys to fight those kinds of cases in order to bring, settlement to the parties who are alleged to be hurt, but also not suck off the possibilities of the Attorney General's office. So my question is, why could we not rely on that kind of process here in Maine for this particular type of crime, as we are doing for a few selected other ones? It just seems to me that, and I'm just worried about the private right of action, and I don't know why it's a needed part of the bill. I mean, I understand what you're saying in terms of Illinois and the enforcement, but I think that to do that doesn't need to put the burden on the citizen. I think that we have an Attorney General who's looking out for us theoretically, no matter who it is. And it just seems to me that that might be a better way to go. So,
Thank you, Representative Reckett. And I'm going to take that as a comment rather than a question to the sponsor and move on to the next question, which is, I think, Representative Moriarty and then Representative Harnett.
Thank you, Madam Chair. Question for the sponsor. What is the statute of limitations for a private right of action under the bill?
So I researched this question with Peggy, and I could dig through. Yeah, this is a good question, and it's unfortunate that Peggy is not here because I can't remember the answer that she provided off the top of my head, but I can search through my email for that particular exchange if you want to keep going, and then hopefully I can pull that up in a minute or two.
No, I don't want to. We have limited time. It's just, I think it's an issue that needs to be addressed so that there's no question under these, under this somewhat unusual context. In other words, I suppose it begins to run when the harm occurred and someone became aware of it. But if that's true, we need a certain beginning point and a certain end point for the bringing of a private action.
Just one comment I'd like to make that is unique to privacy circumstances is that once your data has been breached, sold, disseminated, and it's out of your control, that's forever. So the harm continues forever. So it's just something to think about too, for if you are inclined to put a limitation on, to be very thoughtful about the harm of putting a small one. But I'll look this up as we talk too.
Thank you.
Thank you. Representative Harnett?
Thank you, Madam Chair. And just in terms of process, am I limited to a question or am I able to comment on the amendment to allege?
Go ahead and comment, please.
Excuse me?
Comment, please. If you have a comment, please share.
I think the change to from aggrieved by to alleging makes total sense to me. I'm just thinking about how complaints are structured, legal complaints. You know, you allege violations of the law, which means you're aggrieved by. I think alleging is just cleaner and lines up with the terminology used in complaints. With regard to the private right of action, I would note that this bill, as amended, also references the Unfair Trade Practices Act, which is an example of a law where the Attorney General is authorized to bring an action, but so are consumers who are injured. They can do so on their own. They're almost sort of private attorneys general. That's not an unusual structure to consumer protection statutes. And I understand Representative Reckitt's point that the Attorney General can bring these actions, but the Attorney General cannot be all things for all people. And that's why you build in a private right of action as well. So I support both of those amendments for those reasons. Thank you.
Thank you. All right, committee members, I think that we've vetted this issue and we can move on to the next one. And thank you so much, Janet. Janet, did you have anything from an OPLA perspective that you wanted to share on aggrieved versus alleging?
Certainly. So as I read that sentence, it would allow anyone who alleges a violation of the chapter to bring the suit. So if I believe that Representative O'Neill's information has been stolen, I can bring a right of action. And I would be able to get $1,000 per violation and my reasonable attorney fees, which may be totally what everybody wants. If you want to address what I hear as Representative O'Neill's concern with the possibility of the way the courts might interpret that you need actual damages, you need a true aggrievement. I don't know if that's a word, but you know what I'm saying, to pursue these cases, then it might make sense to do some kind of language, and I can work with Peggy on it if you want, when she's back, to say an individual whose biometric identifier was the subject of a violation of this chapter may bring an action. So you limit it to the correct plaintiff if you think there is a correct plaintiff, but you don't require them to show actual damages. And maybe when you see it on language review, you can see if that addresses the concern in both ways.
Thank you. Committee members, are there any questions for Janet about that concern? Are committee members interested in seeing proposed language on language review that would accomplish that? That it's the concept of you want the person who's bringing the claim to be somebody who is personally impacted rather than just any member of the public. Representative Sheehan?
I actually hadn't thought of that, not being an attorney, and I found it helpful. I'm not sure how anyone else feels, but it was clarifying for me to hear Janet describe that kind of language. So, yes.
Okay,
I
thanks.
too appreciate it. Yeah.
Okay, seems like enough of us are interested in hearing that. So thank you, Janet. And we would appreciate seeing that on language review. Representative Moriarty?
Thank you, Madam Chair. The other, another issue for Janet, I think at this point would be whether or not a class action can be filed. Having skimmed through some of the written testimony from our public hearing, I know that apparently has been a problem in some people's perspective in Illinois. And I don't know whether a class action needs to be specifically provided for, or whether it's simply automatically applicable.
I don't know the answer off the top of my head. I'd have to check the civil rules of procedure, but
right.
I think that under the civil rules, generally you can have one, but I would not want you to rely on that without me checking.
Sure. Okay.
Thank you for raising that issue as well. Okay, so now we're going to move on to the next issue, which has to do with one proposal and that we most recently received regarding changes requested related to medical and biopharmaceutical research. And so we have actually several paragraphs of additional language that we have been requested to include, and this hasn't been circulated to all committee members. And we can look at the language, but I first want to turn to the bill sponsor who has also seen the language and get your comments, Representative O'Neill.
Thank you, Madam Chair. All right, please hang tight with me for a minute while I sort through the different things I have open. Find this one. All right, this should be it.
Is there a screen share possibility here,
I
Madam
think
Chair?
that would be helpful too for process.
Okay. Yeah, and Janet, I don't think that I forwarded this to you. So I'm going to forward it to you right now. So give me one moment. Should have thought of that ahead of time. All right, so thanks, Janet. And I did want to let committee members know, this is one concern about the wanting additional language to be added to create exceptions. And we have received others throughout the course of our work on this bill.
Shall I share it now?
Yes, could you please, Janet? Thanks.
Do you want it zoomed in anymore?
That's a good magnification. And if you could go to page 22, excuse me, page 2. I just want to give committee members a sense of kind of what the proposal is. I think we've had an opportunity to read that. Could you bring us to the next suggestion, please, Janet? Okay, and then the next one. Okay, and then I think there might be one more as well. Page 9.
This is the summary, I think.
Oh, okay, great. Then I guess we don't have to do a deep dive into that. Thank you. So let's just hear, before we focus on the substance of these, let's just hear briefly from the bill sponsor, because I know that she had some communications with the representative of pharma.
Thank you. So I'm not sure if this is exactly what was proposed at the public hearing, but two separate healthcare related entities both proposed exemptions for research. They wanted human research to be excluded from the definition of what a biometric identifier was. So if Janet could scroll up, what I want to show you is that this request is a duplication of something that I already accommodated and put in the bill in subpart I. It says information gathered for human research purposes. If we, and I'm sorry, my computer's just being a little slow with everything. Okay, so I read through this, and I also, it was a quick turnaround time because I received this yesterday evening, but I was able to reach out to a longtime congressional staffer who actually drafted HIPAA. He was the guy who drafted it. So I reached out for his input on how all of these requests fit together, and if the request was reasonable, if it duplicated what had already been asked for. And he noticed a couple of things. So he noticed that in subpart C, if we scroll up a little bit, we're already referencing a biological sample. And he also noted that in subpart I, we have already included an exemption for human research purposes. So considering that this would just create a second human research exemption, I have drafted something that I think captures what the representative of the pharmaceutical companies would like to see. And it would amend this subpart I to say information collected, used, or disclosed for like healthcare research. And I think I would want this to be vetted by the analyst for HHS, just to make sure it makes sense in our scheme of what's in Maine law. And if we scroll down a bit more in the definition section to the proposed addition to number 6, it adds a definition of what research is. So research means a systematic investigation, including research, development, testing, and evaluation designed to develop or contribute to generalizable knowledge. And that definition, this expert that I spoke with was comfortable with. And he suggested saying, and that is conducted in accordance with the federal policy for the protection of human subjects, 45 CFR Part 46, or other similar research ethics laws, or with the good clinical practice guidelines issued by the International Council for Harmonization. And he said, just for folks listening, I suggest leaving out the reference to the FDA's version of the common rule entirely. There are more than a dozen similar versions by other federal agencies. Mentioning one is okay. Mentioning two, as proposed by the lobby group, creates lack of clarity. So the added and other similar research ethics laws, make sure it covers them all. So I can send this information over. I made a phone call to the representative last night, but haven't had the chance to discuss it. I think this is really cleanup language and something that I can send this draft over to Janet and have that reviewed. And I'm happy to consult with stakeholders on whether that makes sense to them. And if we scroll down to the next change requested, yes, it's subpart E. This I cannot do because it asks for something not that we haven't seen before in these biometric laws, and we have already given research entities an exemption above for the information that they're processing for research. This exemption here would exempt things like using facial recognition cameras on public roads outside the facility. So it doesn't pertain to the healthcare information that they are processing. It gives a total exemption. And for that reason, I cannot agree to that exemption. And I had already had a conversation, I believe, with this representative where I, from the representative of the client, where I made it clear that that was something I couldn't accept. So this represents bringing something back in that that I think wouldn't be fair. It would give somebody special treatment. And that's my take. And I can send over the language that I don't know if that was clear or not, because it's all the detail I had to go through last night as I looked it up. But the simple version is we already have an exemption for research from the definition of biometric identifier. And I have a suggestion for a way to harmonize the two things that have been said. And I think some of what's suggested here is good and makes sense. But I got some input from an expert that cleans it up, because it would create a duplication in the bill that is just not good drafting.
Thank you, Representative O'Neill. And yes, please do email that to both Janet and Peggy. Representative Thorne, go ahead with your question
Thank
or
you,
comment.
Yes. Representative O'Neill, you keep referring to the expert that you spoke with. Is that a name that you can share with us?
Absolutely. He's a gentleman named Bob Gelman. I don't think he's someone super public, but he worked as an analyst for a very long time on the Hill.
Okay. And if I may have follow-up, Madam Chair?
Yes, go ahead.
Are you aware of any on a national level bill along this line, or is it just the one in Ohio that you're looking to piggyback off?
Thanks for the question. There is a national level there. I don't know what the status of it is, but it was a bipartisan effort sponsored by, I think it was Senator Merkley and actually Rand Paul too, I think, but I couldn't confirm, but it was a bipartisan effort.
Because like I say, I think this would be effective to a lot of private industry as far as restriction of this process and determining where the line gets drawn between, government being able to restrict a private industry within the confines of their building or in public, and where that line is drawn.
Thank you, Representative Thorne. Representative Babbage?
Thank you, Madam Chair.
And
Representative
Janet, could
O'Neill.
you end the screen share, please? Thank you.
Well, with regard to E that you referred to in the screen share, I noticed there was a reference to the International Council on Harmonization, and it said, or the FDA. Is that part of the objection, the or I'm not, I hear what you said about your objection, and I thought it's well-founded, but I'd like to understand it a little more if you can help me with that.
Absolutely. My suggestion is don't include E. And the reason is it would completely exempt an entity, and the way that we have based all the other exemptions in the bill has been around information being processed because you're doing it for research, but it's about that specific healthcare information. It's not about everything that they do. For example, using facial recognition cameras for surveillance on public streets of people, regular people walking around, that kind of thing. So it's got to be fair to everyone. This would treat this one entity differently than everybody else.
Representative Evangelos?
Thank you, Madam Chair. Madam Chair, I'm sorry, I have to leave. I have an appointment, but I did want to speak to the sponsor. You're doing important work. It's visionary. I know it's so far ahead of its time that it's difficult sometimes to grasp the concepts, but they're real and can lead to some pretty frightening consequences. So I just wanted to tell Representative O'Neill that I'm committed to supporting hopefully an amendment that can come out of committee today. And I will follow up with the committee clerk and cast my vote after I consult with my colleagues regarding the outcome of today's hearing. And sorry that I have to depart, but everyone have a nice weekend, and we'll see you next week.
Thank you so much, Representative. Okay, committee members, I think we've kind of vetted this this issue, and I did want to point out that I appreciate, Representative O'Neill, that you're going to give us some additional language on the definition of research, and also wanted to note that particular issues like this are things that can be addressed in the study that will occur if this legislation is passed between the passage of the legislation and the effective date. And so this is, I know that there are others who also would like to suggest changes in language. It's just not something that we can accomplish today, given that this is the last day that we are able to meet on this bill. Representative Sheehan.
Thanks, Madam Chair. I just want to kind of get this question out there. We don't have to talk about it now. We can maybe talk about it at the end, but because I'm not familiar with this process of passing legislation, but also convening a study commission, I'd just love to hear a little bit about what sort of leeway the commission has to amend what we pass. It might be a rookie question, it probably is, but if we can talk about that at some point, I'd love to hear people's thoughts.
Thank you. Yeah, we've got two more issues to address, and then we can begin kind of a more general conversation. So the next issue, and this is something that OPLA also raised, has to do with section 9605 subparagraph 2 and the sequencing of the disclosure of information and obligations under the statute. And Janet, could you please screen share that section and then just walk through the concerns that you and Peggy raised?
Sorry, I just,
Page 5, I think.
Mhm.
the problem was the other version was up and I couldn't tell when I was screen sharing which one I was about to show.
Thanks.
Sorry.
Do you want me to explain this, Senator Carney?
Yes, and the concern that you and Peggy raised yesterday.
Sure. So if you read subsection 2 here, well, first, an individual would request disclosure of what biometric identifiers the entity has and how they're being used. But if you read the way this is worded, it says that the information that must be disclosed includes all the relevant information for the period 12 months before the identifier was collected. And yet, if you read down here, the information to be disclosed is the use of the biometric identifier, which would not have occurred before it was collected, or the type of entity with who it was shared. But again, that would not have occurred before the private entity collected it. So I think I understand what this is trying to do. And we had a similar bill in BLA earlier. So when I was talking to Peggy, we had an idea of maybe, I mean, it wasn't a similar bill, but it had a similar type of phrase in it. And I think Peggy and I thought maybe saying instead that the information disclosed as required by subsection 1 must include all the relevant information for the period, instead of, you say beginning 12 months before the identifier was collected or entered. And then after this word entity, you'd say, and ending on the date. And I don't know which choice you would want to make, but there's two possibilities, either ending on the date the request was made or ending on the date the disclosure is made.
Okay, let's leave the screen share up for a minute. And Representative O'Neill, can you give us your thoughts about this?
Thanks. Okay, so I'm trying to follow, and I think just because this is a new conversation. Striking of and replacing with beginning works for me, and I think I need some help with the second piece, which is the more substantive one.
So the question is, do you want the disclosure to be through the date that the request was made or the disclosure? Because I don't know how long it might take to answer. So let's say it takes 3 days to answer. And should the entity then disclose from the date the request was, through the date the request was made, or also whatever it did in those 3 days?
Okay. For some reason, this is not processing for me, and I'm just, I think I just have too much in my brain. Okay, so I just you need to just say it again, I guess. I'm not following.
Certainly. So you'd want the disclosure to be 12 months before they collected the identifier. That's just how it reads now, so I wouldn't want to get rid of that unless you direct us to. But beginning then, and then once they get the identifier, after they have it, they might engage in some of these activities. So you need to have the disclosure include things that happened after they obtained the identifier. And the question is just, when this request is made, do you want the private entity to respond with everything through the date the request was made, or through the date that they answer the question? So if it takes them 10 days to answer the question, do you include all that? And I just don't know how difficult it is to compile this, and if I just don't know how feasible it is, or what from a policy perspective you prefer.
All right. Thanks for the question. Okay, I think I get it a little better, and I'm sorry I'm being slow. Yeah, I'd have to consider it. I saw a hand up, and I think I just want to ask the experts on this, I suppose, but yeah, maybe we could go to the next item and you could give me a moment just to process what I think I understand.
So we've got 2 hands up, and let's take those hands up and just keep the screen share up, because I think this is a little complex, and it's helpful. Representative Harnett, if you can go ahead.
Thank you, Madam Chair. And this is a question for Janet. The second language you're talking about, not the deletion, not the change of the word of, but the and ending on. Does that comes after the word entity? Is that correct?
Unless that doesn't work grammatically, that's how I wrote it on my notes.
Could you address that by saying an ending on the date of the response?
Yes, that was one option I presented. I didn't want to presume to know what you would say, so that would work.
And that takes out the concern, is it, what happens in between the request and the response? Am I right there?
It does, and I wasn't suggesting there should or shouldn't be a concern. I was just saying you could have 2 options of when the end date is, and I leave it to you as a policy choice of which it should be.
Okay, thank you.
Representative Harnett, did you have a suggestion as to the policy date that would make sense to you?
It would be the date of the response.
Thank you. Representative Sheehan?
Thanks, Madam Chair. I was just going to say the same thing. I would want to assure someone the most comprehensive report of how their information has been used. So I'd be inclined to want to see, the respondent include as much of that activity as possible. And I think picking the date of the response would better assure that.
Thank you. All right, and so it seems like at least the committee members feel that there is a good path forward on this issue. So let's go on to the last one. And actually, Jen, I'm going to ask you to screen share again. And this has to do with section 9606, subparagraph 2, and the concept of a processor and profiting. And Janet, if you could please explain to us the concern that you had with this language.
Sure. Sorry, I was writing something down. Okay, so as I read the way subsection 2 would go into effect if you adopt this amendment language, it would prohibit a processor from processing at all from the biometric identifier. And I read this with literally no knowledge of how this whole thing works because I haven't been involved before. And it occurred to me that isn't the processor's job, or what they're hired for, to do something involving the biometric identifier. So they should in fact get some profits from that, or else perhaps they wouldn't be a business. And so my understanding, if you look down in subsection 4, is that they're not supposed to do anything beyond what the contract allows them to do. And if that's true, then I don't think you need them up here, because I think you're being very tight down here, but I could be wrong. So I just wondered if you were making it impossible for a processor to exist unless there's some free service out there. That's all.
And so, Janet, are you suggesting that some of the language that's currently proposed in that paragraph 2 would be better to be removed from the document?
Well, if you agree that the goal is only to limit the processor to doing exactly what they've been contracted to do and no more, if that's the goal, I think that's captured in 4, and then you don't need it up here. and including it up here suggests that a processor's business model cannot involve the use of biometric identifiers to do anything for a private entity because they can't make money from it.
And so would that be accomplished by keeping in the language that the entity or processor that collects identifiers may not sell, lease, or trade those identifiers, period?
I was thinking something different, and maybe we're not on the same page for a good reason. So what I was thinking was, as a private entity that collects the biometric identifier, I believe the goal is to not allow them to sell, lease, trade, or otherwise profit from the biometric identifier. For the private entity, I believe that you want all of those prohibitions. I believe my understanding is the prohibitions you want on the processor are down in 4. And so you don't need them also in 2.
Okay. Let's hear from, thank you, Jen. That was a much better explanation than I could give. Could we hear Representative O'Neill, your comments on that suggested language?
Thank you. So again, like processing as quickly as I can, but I agree with what was said about subpart 4, about how that lays out that they need to do what they're doing, according to a contract. I think what is being flagged here, and I agree this is a point to look at, could be solved by removing, as Senator Carney said, otherwise profit, because I think that gets to the point of what we are saying. And it is a duplication to say that a processor can't do this outside of the contract, because it still would be within the contract. I don't know if I'm making sense, but
yeah. Representative O'Neill, I guess I'm just thinking this through right now for a second time, but I kind of feel like the otherwise profit language is important for private entities that are not processors. Do you think that's the case?
Well, I'm trying to think of another example to cite too, but a lot of this draws on ways that a lot of privacy laws are drafted. We'll try to say, don't sell it, don't lease it, don't trade it, or some other thing you might come up with doing it or calling it. So that's what that catch-all phrase is for. But the intent was not to prohibit them from being a business. So I think as a drafting matter, the committee could signal what that intent is, and hopefully we could work on fine-tuning it so that it doesn't have the effect of saying you can't be a processor, but saying that you can't sell it or profit from it in those ways that we don't want.
Okay. All right. Thank you. Representative Reckitt?
Yes, when I looked at this issue just now, my initial reaction was, so we keep 4 as amended and we throw out 2 entirely. And then I realized that wasn't right either. And so I think that, but I do think that it's important that we ban the, sale, lease, or trade. But I'm thinking about, let's say there's and this is totally off the wall. Let's say there's a bank that does this and decide, well, gee, we're having trouble financially. Maybe we could just sell these biometric things, and get some money for them somewhere. They're not a processor. They just happen to have all the information. So it looks to me like the number 2 would protect that. So it isn't, some Johnny-come-lately who has the information but isn't a processor can't sell it. And then down here, it restricts processors to only do things under contract. Is that true? Am I totally lost my mind?
And the other thing is that in the definition of a private entity, earlier in the legislation, processors are excluded already.
Okay.
On page 2, processors are excluded from the definition of a private entity.
Okay, so I'm clearer now. Thank you.
Yeah. Okay, so I feel like we've, any other comments on this issue? Representative Babbage?
Oops. Thank you very much, Madam Chair. Janet, thank you for what I consider another good catch. But is the prohibition for leasing, selling, leasing, and trading, is that prohibition in Part 4?
Is that a question for Janet?
It is.
Okay, thanks.
It is. In other words, is the processor explicitly prohibited from selling, leasing, or trading, but is being permitted to profit, not doing those things according to contract?
So it doesn't use the exact same language in 4, and you could make it mirror it. I think it gets at that by saying you can't use it or disclose it, which you would have to do to sell, lease it, or trade it. But it's always dangerous to use different language in one part of the same statute than you use in the other part if you wanted to cover it. So I think you could just mirror this language down here. You can't do any of these things unless it's allowed by the contract, if that's your concern. And I just wanted to clarify what I said before, is I think it would make sense if you want to be very broad in your prohibition against private entities to be very broad in subsection 2 and just apply it to private entities, and then be slightly more narrow in subsection 4 and focus on processors there. And the only slightly more narrowness of it is to say, yes, you can have your own business of providing a service to the private entity, but that's it. That's where it ends. And then you can mirror all the language that you want.
So in your opinion, Janet, and I think that's very clear and wise, but do you think, as it currently is worded, does section 4 provide explicit prohibition for processors to, sell, lease, and trade?
So that's where I'm being a lawyer. I think you could argue that it does, but I think somebody could argue that by using different language, it may not. So the question really is, what do you want to prohibit? And we'll write it to say that, so that somebody will try to prevent somebody from arguing the other way.
Thank you.
Thank you both. Representative Harnett?
Thank you, Madam Chair. And I'm not sure if this is a stupid question, but with respect to paragraph 4, I am more comfortable putting in those words from subsection 2. And I have this just concern in the back of my mind. What if the contract allows you to sell, trade, lease that information? So the process would not be violated, would not be acting beyond the contract. Do you understand my concern, Janet?
Yes, so you can say that the processor may not, and include anything in here that as a matter of legislative policy, you don't want them to be able to do. And then you have this language about, but anything else you do has to only be under the contract. You can be very clear in both ways.
Okay. I'm more comfortable with having something that makes it clear in subsection 4 that you cannot sell, lease, or trade. I know you think it's covered in there, but I just want less to people to be able to.
I think you raised a very good point, and it may not be if the contract allows it. So I think you could say both.
Okay, thank you.
So committee members, are we comfortable with asking Janet and Peggy to come back to us for language review with language that would focus paragraph 2, the prohibition on private entities that aren't processors, and then that would also tighten up paragraph 4 to confirm that processors can engage in a contract to process, but cannot enter into a contract to use, disclose, or sell the biometrics. Do we feel like that's a good direction to head? And Representative O'Neill, is that your intent?
Thank you, Madam Chair. I agree with what Representative Harnett said and would want to move ahead that way. That's a good plan.
Okay. Representative Reckitt?
I have some larger issues that I really feel we need to talk about, and I'm worried about the time. So
Yeah,
let
we're
me
gonna, I'm sorry to interrupt you, but
Yep.
as soon as we deal with any additional questions on this, we're gonna launch into that conversation.
Oh, okay.
And I will call on you first.
All right, thank you.
Thank you. Representative Thorne?
Thank you, Madam Chair. And I may be missing it, but is there anything that restricts the government from this or just private entities?
The
If the
government's
government has
exempted.
it,
The government's not included in the definition of private entities.
but if the government has this biometric information, this doesn't prohibit them from selling, profiting, or passing along? Only private entities?
In this law, there may be other laws.
Okay.
That's how I read it. I could be wrong.
I just wanted to be sure that I wasn't missing it.
Thank you for the question, Representative Thorne. Okay, committee members, I feel like we, as Representative Reckitt suggested, we really need to change gears and talk about the policy issues rather than the language issues. We also, I just wanted to let members of the public know and alert committee members to the fact that we do also have a separate proposal for consideration by the committee that is a standalone draft study. So what we've been looking at would pass legislation with a delayed effective date and have a study group convene, a legislative study group convene to look at specific issues in the interim between sessions and address things like the proposal from Pharma for additional language and other suggestions by impacted industries for language changes that we're not going to focus on today. That would give an opportunity to hear out and consider additional amendments to the statute between sessions. The study would not include passing the legislation, but would be a study of the issues that are raised by LD 1945 with authority to for this committee to report out legislation in the 131st. And before we, I neglected to ask committee members if anybody had questions about the language proposed in the draft study. Representative Moriarty?
Clear.
We're not able to hear you.
Thank you. There were some rather distinct differences between the draft study bill that Peggy sent us on the 24th and the Part B study bill, if you will, that was sent to us yesterday by the sponsor, among which includes Peggy's language regarding an emergency preamble and a few other things. And so I think rather than discussing the distinctions between the two versions of the study, I would suggest that we talk about the general path forward and then try to reconcile the two.
Okay. Yeah, and I will point out to you that as I looked at the original draft study language, the study that would happen if the legislation were not passed with a delayed effective date would be a different kind of study, actually, because it wouldn't be based on that specific legislation. And so you'll see, and I worked with Peggy to suggest language. And so if you look at, for example, the page 3 of that proposed study, paragraph 7, that's very different than the paragraph 7 in the document we've been looking at. And that's a product of the fact that they would really be two very different exercises, actually.
Yeah. Agreed.
Yeah. And I'm happy to answer any questions about the study language that people might have.
I will, I won't hold the floor. I'll yield to my colleague, Representative Reckitt.
Okay, thank you. Representative Reckitt, do you want to begin our general committee discussion?
Yeah, I have some significant concerns on a couple of fronts. One of which is directly involved with the committee. And I think it's the same concern in both drafts, because they're both legislative committees composed of legislators, right?
Yes.
And that's my concern. I mean, I'm concerned about the composition of the committees. This is a huge, important topic that's going to affect a gazillion of us. And no offense to my co-legislators, you'd be hard pressed for me to tell you which 7 people in the House and Senate I thought had the capacity to look at this project and in 6 months or whatever it is, come up with the really important stuff. I don't think it's the right faces at the table. Now, I know they can bring in people who know stuff, but we got to identify who those people who know stuff are. And I would rather if I could wave a wand, I would want all of the people who are invested in this, both pro and con, to be duking it out in a large committee until they came to something either close to consensus or at least that could be articulated how we ought to think about it. And I don't know that that's 4 reps and 3 senators or whatever the composition was. And I understand why you would have a committee like that, because that's how you can get it funded. That's how you can get it staffed, all those kinds of things. But I'm just not convinced that that's the group that's going to know best what we ought to be doing. So that's part A of my concern. My part B is the timing of this thing. And I don't know whether I'm not clear whether the proposal for the committee is necessarily, well, it's tied into the, well, I guess what I'm concerned about is whether or not the committee's only choice is to report out a legislation based on this particular legislation we have before us now, or whether something entirely different. I don't know. So I'm concerned about the knowledge base, no offense to my co-workers in the legislature, about whether or not we would have the right people. And if we did have the right people in the legislature, which is entirely possible, then would they or would they not be predisposed to whatever knowledge base they're working in or have experience in, or it just feels, I don't know, it just doesn't feel right to me. So I don't know what to say about that, except that I'm not comfortable with this committee in its current composition. And I continue to be concerned about the concept of passing the bill, having a committee, but by the way, we're implementing in 6 months anyway, unless you happen to get the legislature to make amendments or do something. So if I'm totally missing what that proposal is, let me know, but that's how my brain reads it right now. And I'm uncomfortable.
Thank you, Representative. I will just address the issue about the composition of the committee. And that is that the reason the composition is legislators is because the stakeholder group is actually very broad. And by having policymakers compose the committee and bring their policy focus to the committee process, it gives those 7 policymakers the ability to reach out to stakeholders who are very important to this process, who we might not even know right now would need to be part of the stakeholder group. And so so that's the primary reason, is to have the policymakers kind of in the driver's seat on the process, and to have a broad menu of stakeholders who could be pulled in, and not have that limited by the language or composition of the group.
Well, that makes me feel a little better about that piece. Thank you very much for that.
Okay, you're welcome. Let's get other legislators to weigh in. Representative Babbage?
Thank you. Yeah, I think I understand where Representative Recker was coming from, but I think I disagree with the basic premise, because if we were a banking committee, I don't feel that the legitimacy of our decisions would be improved by, and I'll pick on banking here, but by having a banking lobbyist be a voting member of the committee. I really feel that we have some very interested stakeholders. They will not be omitted from the process. So I'm more comfortable with that, and I appreciate the broadness of who. I mean, technically, this bill affects everyone. So I think for efficiency purposes, I'm not concerned about the makeup as presented. I would like some clarification, though, from the chair as to the choices, the differences in choice regarding the study committee that I'm not quite clear on. Could you do that for me, Madam Chair?
Yeah, I can. Give me just a second. I got to line up my documents here. So the differences really are in two places. One is the duties section, and I'm sorry that I'm not looking at the screen, but I have to look at the documents. The duties section, which is section 5 of the study language. And you'll see that the duties section of the study are a little more extensive and also a little more specific. And so I'll just point out a couple of examples, and we can do a deeper dive into any of them that you prefer. But for example, in the combination proposal, duty section 3 is review available enforcement mechanisms. And then if you look at the duty section 5 of the study language and go to paragraph 5, that talks about the enforcement mechanisms. It says, identify the remedies and enforcement mechanisms that have been used in other jurisdictions, the extent to which they enhance compliance with state regulation of biometric identifiers, and other impacts of the remedies and enforcement mechanisms. And so it's not just looking at available enforcement mechanisms, but in the draft study language, it would be more of a like policy-based evaluation of them. And again, because the purpose of the study is to bring legislation back to this committee in the 131st. And I can, another distinction is that the combined document doesn't have the recommendation language in paragraph 5 of the combined document is to develop recommendations to improve and assist in the implementation of this legislation. Whereas in paragraph 7 of the standalone study, it itemizes a request to make recommendations regarding legislation to protect an individual's privacy with respect to biometric identifiers. And then it highlights 3 specific things to look at. What is the definition of identifiers, or what's the scope of it? What are the shortcomings in state law that need to be addressed in order to protect privacy? And then recommending remedies and enforcement mechanisms that will enhance compliance with state regulation. And so they're different. Those are, I think, kind of the main differences.
Thank you for that. And the timing of the 2 proposals are simultaneous, or are we borrowing from I mean,
Well, yeah, it would depend on ultimately what the House and Senate pass and what makes it across
Sure,
the
sure.
chief executive's desk. Because one would be the legislation with a delayed implementation date and an interim study, and the other would exclusively be a study.
May I hear the comments of the sponsor?
Yes.
Oh, thank you. And am I just commenting generally or
On the study aspect.
on the
Um,
study aspect?
yeah.
So I think what I would say is that these protections already exist in other states. We've seen how they've played out. Privacy laws exist. We just don't have them here to protect Mainers. So I think I would say adopt these protections as a compromise. It didn't come from me. Folks suggested pushing back the implementation date and giving stakeholders a chance to weigh in and discuss what that would look like. Upon reflection, I thought that sounded okay. So I'm making that suggestion here today, and my lead co-sponsor, Rep. Andrews, supports that as well. So that's what I'm presenting. I don't think a study alone is going to accomplish very much because stakeholders don't want to be regulated. They don't want to have to get consent in all of these situations. I think you can do that.
I understand that. Yeah, Representative O'Neill and Chair Carney, I have the shorter version before me, review available enforcement mechanisms for number 3 and develop recommendations to improve and assist on the implementation of Chapter 1057. Is that what's being recommended and for us to consider, or is the more lengthy language, new language that has just been put before us?
I am just suggesting what got submitted to maybe the chair can explain the 2 reports again.
Yeah, so 2 reports were circulated publicly into committee members yesterday around 12:30. And one of the reports is the bill language and a study that has slightly different language. The other document, and we can screen share it, Representative Babbage, would it be helpful to you if you see just the standalone study on the screen? Yeah. We're not able to hear you.
You're muted, Chris.
Yes, I'm sorry. And I apologize for this. That would be helpful, but if I can find it myself and I'll try to.
Because we're short on time, I think Janet might be able to do it pretty quickly. Thank you, Janet. Okay, and so let's scroll through the emergency and then just look at the differences, which would be in the duties section. And and so Representative Babbage, if you want to just, it's on the screen now, and any questions that you have, feel free to raise.
Is this a proposal for a study that is standalone, or is this part of the bill?
This would be the standalone for folks. I had the sense that committee members were not some committee members might not be comfortable with the first proposal, which is to pass the bill with a delayed effective date and the interim study. And so I wanted committee members to also have language to look at that would be a standalone study.
Thank you.
Yeah.
Thank you for that.
Do you want to see more? You want to see the remainder of the duties, Representative?
If you could scroll there just briefly, thank you. Okay, thank you very much.
Thank you. Thanks, Janet. Representative Moriarty, and actually before you begin to speak, I just want to let committee members know that I'd like us to have another 10 minutes of discussion, and then we'll take a 5-minute corner caucus, and then we'll come back and vote. Representative Moriarty, go ahead.
Thank you, Madam Chair. I just want to remind everybody that 2 days ago, we dealt with a somewhat similar complex piece of legislation, the bill from Representative Madigan. And it came to us in the form of a fully drafted bill. And based upon the response that she received and the feedback, she withdrew that and proposed a study. So in that case, the study was approved, according to my notes, by an 11-2 bipartisan vote. And there was no adoption of a bill first to be followed by a study. Instead, we agreed to the usual format, which is study the matter first, have the committee make recommendations, and then reconvene and crank out a bill on our own. So, having said that, I prefer the standalone study provision for that reason and for a couple of others. I think it's extremely awkward to pass legislation with a lengthy effective date, and then in the period of time being so long that the study committee will actually have completed its work and made its recommendations well within the period before the bill becomes effective. I understand that the sponsor has said we need some protection now, but even with whether it's 11/1/23 or 1/1/24, we're not going to get protection now with the bill as drafted. I prefer that we go ahead with the study group without reference to a title of the main revised statutes, because we will not have actually enacted anything. And we have plenty of time. If it's passed as an emergency, the committee has 3 extra months to do its work and meet the November report date. And then when whoever is left among us reconvene in January of next year, we have plenty of time in the first session to propose and put forward a bill. I also want to avoid, if that were to happen, I would want to avoid any sort of period of time in which the bill as presented now takes effect first, and then within a couple of months, a revised bill takes effect. That, I think, would be destructive, confusing, and very damaging to all of those invested in this process. I have some concerns about a legislator-only committee, but if it's understood that the committee can freely invite people to attend and participate, and in fact that they are encouraged to invite those interested with more knowledge, then that may take care of that. That's all I have right now.
Thank you, Representative. Representative Thorne?
Thank you, Madam Chair. And it may be no surprise to the committee that I'm opposed to this bill in the sense that I think it infringes upon the right of private entities to be able to do something. It excludes government from being able to do the exact same thing. The all legislative committee turns government of the people, by the people, for the people into a government of the government, by the government, for the government in the decision-making process, which is, again, something that I'm uncomfortable with. And my list of questions, if I was to be animated, would be a funnel over my head. And what came out my mouth would just be a jumble of questions that I have. And I don't want to overwhelm the committee. I don't want to overwhelm Representative O'Neill. But the concept is so new and has so much yet to be determined. And when we talk about stakeholders, they should have more than input. They should have a vote, a say, even if it's a vote of dissension or a voice of dissension to the concept of restricting the collection of it. For many, many years, we've gone around and we've done raffles hey, put your name here in a raffle. Just put your name, address, and phone number in this bucket. Well, those of us that know now, those lists get sold. We buy a car, we give information. People come to that car dealership and they sell that. The government sells our information to people that want to target and market to us. Inland Fisheries and Wildlife, you buy a hunting license, you buy a fishing license, you can go there and buy the list of names of people that have bought and all their information. So to distinguish private entities only, and I got started, so I won't take the committee's time, but I am a straight ought not to pass on this proposal as it stands. Thank you.
Thank you, Representative Thorne. Representative Poirier?
Thank you very much, Madam Chair. And first off, I want to thank Representative O'Neill for all of the hard work she's put into this, and also Janet. I do think that this is a very important bill and that Mainers do need protections in this aspect. I very much agree with that. I do, however, echo the concerns that Representative Moriarty spoke of. I hesitate to put my name as a yes on a bill that I don't know what the actual bill will end up being at the end. Therefore, I would also go along with a study alone, but not the bill as it stands just yet. I still think there's some work to do, but the concept of it and the protections that it provides, I am very in line with. Thank you.
Thank you, Representative Poirier. Representative Babbage, I know that you've had a chance to address the committee a couple of times, and we're going to break for a caucus in just 3 minutes. Is there anyone else who would like to share their thoughts before we break for a caucus? Representative Harnett?
Just very briefly, and because I think we do need to caucus, just a couple of points. What we did with respect to the bill that was brought to us by Representative Madigan had a lot to do with the timing that came before us. It was a major bill that we heard in the last week of session, the last week of committee meetings. We've been working on this bill for over a year. So I think they're in very different postures. With respect to, names and addresses that you put on a raffle ticket or the information that is sold by IF&W, I think we need to remember what we're talking about here. We're talking about personal biometric identifying information. I think it's very different and rises to a much higher level of concern for me than my name and address, which is located in the phone book. So I just want us to remember the issues that we're dealing with, but I'll save my comments for when we vote. Thank you.
Sitting here.
All right, great, thank you. Anything else before we break for our caucus? Representative Moriarty?
Madam Chair, just a question about Chair Harnett's comments. The bill is dated January 26th of this year. Have we in fact been working on this for a longer period of time? Our public hearing was just over a month ago.
I'm sorry, I misspoke on that.
Okay,
I'm saying
thank you.
we had a much more earlier in the session than we did the bill that we just addressed.
Okay.
All right, committee members, at this point, let's take a 5-minute recess. Let's try to get back at 10:50. And we do have a firm end time of 11. And so if we return at 10:50, we can move directly into a vote. And
Madam Chair,
yes.
I need to make a statement either now or right before we vote. I have a statement to make about where I stand, which I had not shared. So, thank you.
Okay, let's, why don't you go ahead and do that?
Okay, I will vote to expand the right of privacy this year. We've already begun putting legislation that protects the policy protects the privacy of individuals from government access in various measures. We've not given citizens the tools to protect privacy from large corporations. So with regard to Illinois, I just wanted to say that, 13 million people, the law was passed in 2008, 1,000 cases. If we put that in the format of Maine, that would be 100 cases over 13 years. I don't think that's when we're talking about what we're talking about, putting consumers in control of their own information. The AG's Consumer Protection Division has been effective in after the violation justice, but with the limited tools that we've given them. But we're allowing them to continue that work. But having the private right of action properly puts in an individual citizen's hands the tools for redress that will be taken seriously by those who collect and commercialize data. So supporting these privacy protections for Maine residents that help each of us to know what personal information is being used by whom, for what purposes, and to have that enabled only by explicit permission, I think is a wise way to go. I like the idea of the study. It specifically in the study language says to improve. So any alteration that they choose to recommend next in the 131st will be entertained by the 131st legislature, but with the hammer that a privacy interest will be in law in the fall of 2023, I think is a good idea. So I'll be
Thank you,
approving the bill
Representative.
as represented. Thank you.
Okay, and committee members, so let's do a quick caucus and we will return in 3 minutes. Everybody remember to disable your audio and video. Thank you. Committee members, if you are able to return to your desks and activate your audio and video, we can finish up with our work session on LD 1945. It'll just take a moment or two for everybody to return. I hope that in the 131st, when we're returning from caucus, we're walking back and forth instead of toggling between screens. Let me just check and see if we're missing anyone. Just Representative Babbage. If you're able, Representative Babbage, to return, please do so. Okay, I'm not sure. There we are. Great. All right, we're all back. And at this point, I will recognize Representative Harnett for purposes of making a motion.
Thank you very much, Madam Chair. I will make a motion to adopt the combined, what we're calling the combined bill, so the committee amendment to LD 1945, with the amendments that we discussed today, recognizing that some of those will come back to us on language review, and making the effective date of any of the legislation January 1st, 2024. Given the time, I will not give a speech other than that I think these are critical issues that we need to deal with them now, and that the study committee, although unusual after a bill is forward, could simply make the bill better. So it's the reason for my motion.
Thank you very much, Representative Harnett. Is there a second? Representative Moriarty?
Clarification, a point of order, Madam Chair. Did I hear Chair Harnett say 1/31/24?
No, I meant to say 1/1/20.
Okay.
January
Okay.
1st, 2024.
Got it. Thank you. Yep.
Thank you. And Representative Babbage, are you seconding?
I will, but I have a question, quick one.
Very quickly, because
I
we've got
just
4
need to
minutes
know the
to complete our
motion
vote.
includes which amendment, Representative Harnett?
The motion includes
Which study period?
the effective date of the legislation would be January 1st, 2024. The study committee that is explained in the combined bill is the one. I'm moving the complete combined bill, not the freestanding study.
Thank you very much. Thank you, Madam Chair.
Okay. Janet?
I think I understood everything about Representative Harnett's motion except the pharma piece. That part I didn't know.
The what piece?
The pharma suggestions. And then Representative O'Neill had a response, and then it was sort of set aside, and I wasn't clear. Were you including Ann Robinson's suggestions or just leaving that out and leaving it as is for now?
Leaving those out and leaving the proposal as is. But I see
Okay.
the chair has her hand up.
Thank you.
Yeah, and I believe that we were going to have some additional language suggestions on that particular issue from Representative O'Neill. And just to clarify, Representative Harnett, would your motion incorporate those changes, which again would come back to us on language review?
From the bill sponsor, yes.
Thank you. All right, Representative Knoll?
Thank you, Madam Chair. Just a point of clarification. My understanding is Representative Harnett is proposing a motion seconded by Representative Babbage that is reflective of Representative O'Neill's original intent of her proposed bill with said amendments. And this vote is separate from the suggestion of not moving forward to enact this bill, but to have a standalone committee. Am I of the correct understanding?
I think so. So this would be the document that was circulated yesterday, which is the passing the legislation with the January 1, 2024 effective date. And between the passage of the bill and the effective date, there would be a legislator-led study to determine whether any amendments were needed to the legislation before it gets implemented. Okay.
Okay, thank you.
Yeah, thanks. All right, so we've got a motion and a second. I just very briefly want to speak. I actually, let's just move on to a vote. Okay, it is time. And Supi, could you please call the vote?
I would be happy to, Madam Chair. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Representative Babbage, we didn't hear you.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
No.
Representative Galgay-Reckett votes no. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Evangelos. Representative Evangelos is absent. Madam Chair, I have 3 members voting in the affirmative, 6 members voting in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much, Supi. And so for those who voted no, I'm going to start with you, Representative Thorne. Can you let us know what your report is?
Absent of a stakeholder on the seat of the study and only legislators. In other words, I don't think it would be right if we had a tribal bill and there were no tribal members on the committee and only legislators. So therefore, this is important to the stakeholders. So I'll just be a straight ought not to pass.
Thank you, Representative Thorne. And then I would like to speak to my report, which would be the study language with a modification to include in section 5 a new first paragraph that would come above the previous paragraph that would include reviewing legislation regarding privacy of personal information and biometric identifiers considered in the 130th legislature. So that would be my report. And are there others who wish to join that report? If so, can you just raise your hands for Supi's convenience?
I may, Madam Chair, there's part of me, I'm just wondering, the motion failed. And I know you're going to have a lot of split votes, but I'm wondering if it might be cleaner just to do another motion.
Okay, we can do that.
And Janet can maybe help me on that one, but that's what we did I believe, a couple, 3 days ago when this happened again, and being nowhere that motion is going to get a majority.
Okay, thank you. I think that that process-wise, that is very wise. And so Representative Moriarty?
Thank you, Madam Chair. I move that we adopt the the standalone amendment, or sorry, the standalone bill regarding the study committee as dated 3/24/22 with an emergency preamble and with the language described by Senator Carney regarding authority of the committee to consider any legislation drafted and reviewed during the 130th.
Thank you. Is there a second? Seconded by Representative Sheehan. I think we are ready for the vote, Supi?
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
No.
Representative Harnett votes no. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos. Representative Newell.
No.
Representative Newell votes no. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Evangelos. Representative Evangelos is absent. Madam Chair, I have 5 members voting in the affirmative, 4 members voting in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much. Representative Harnett, can you let us know what your report is?
Ought not to pass.
But did you have an ought to pass as amended by committee amendment, a different amendment?
Yes, the one that I
Thank-
proposed prior. Yes, sorry.
Okay, thank you. And for those who are joining in that report, could you please raise your hands to clarify for Supi for recording purposes?
Ought to pass as amended according to the previous vote.
Okay. And Representative Thorne, you ought not to pass?
Yes, Madam Chair. Thank you.
Thank you. All right, committee members, we are over time. And I know that our staff has other obligations that they, legislative obligations to go to. Is there any further committee business? All right, I am not seeing any. Thank you, everyone. We'll close the work session on LD 1945. Thank you for all your thoughtful and hard work this morning. Representative O'Neill, many thanks for bringing this legislation forward.
Thanks so much, everybody.
Thank you.
You.
All right, is there a motion to adjourn? By Representative Sheehan, lots of seconds. All right, committee members, thank you everyone for your work today. See you Monday, I believe. No, Wednesday. Thank you.
Tuesday session,
Everyone
Wednesday
Tuesday.
confirmations.
All right,
Scared.
thank you. Bye, everyone.
Have a
Okay.
great weekend.
Bye-bye now. Take care now.